Okay, so we'll get started. So thanks everybody for coming. My name's Orion Irvine. I'm the regional director of the CLC here in the Pacific region. I'm one of the staff that puts on the winter school. We have an exciting panel tonight talking about COVID and employment law. So joining us tonight is Craig Bavis, who is the managing partner at Victory Square Law Office, who is one of our longtime labor friends. Craig has a long history of supporting unions through their cases. He was one of the lead lawyers on the SFL case, which put into the constitutional right to strike, and he also worked on the Health Sciences Association case too, which was a leader on, went all the way to Supreme Court, both those. So very excellent labor lawyer. Also joined by Claudia. Sorry, I'm not going to get your last name right. I should have asked before. So sorry, what's your last name, Claudia?
Arrieta. Hi, everybody.
Yeah, thank
Gotta
you.
roll that R.
Yeah, I cannot roll R's medically. I've tried to, but I can't roll. So Claudia is also an associate at Victory Square Law Office, and we're joined by I'm not quite sure if you're a lawyer yet, but articling student Christina Batstone, but shortly to be lawyer who's articling at Victory Square Law Office right now. So the three of them are going to take us through this presentation. So with that, I'll turn it over to you, Craig.
All right, thank you. So we're going to begin our journey through to COVID-19, and we're going to do our best to try to move through this to leave room for questions. We've broken this down into 4 categories, dealing with work-safe rights, privacy rights, working from home, and what to do when vaccines come on. So if you save your questions for the end, if questions come up while you're thinking about this, I think there is, Orion, jump in if I'm wrong, but I think you've got the Q&A function enabled, so you can type down your questions.
We do. Questions. Yeah, so there's a little Q&A box at the bottom. I also neglected to recognize that I'm on the shared traditional territories of the Musqueam and Coastal First Nations here in South Vancouver, and invite everybody to take a chance to think about where they're coming from tonight. But yes, Craig, if you have questions, please use the Q&A function at the bottom of your screen, and we'll get them to them at the end of the presentation.
Okay, thank you. So before we begin, I just want to give a sense of, COVID-19 and where we are and how BC is doing, and just remind people that when you're discussing COVID-19 and statistics, to just really have a sense of what stats you're looking at. You'll see a bunch of different metrics that are used. The most common are the cumulative total COVID cases and the cumulative rate per 100,000. Additionally, there's the 7-day average cumulative and the 7-day rate per 100,000. Be aware of what you're doing because they can paint a different picture. I think the most useful is to look at the new cases per 100,000. And these are published by the Center for Disease Control on a 7-day rolling average. And you want to get a 7-day average because reporting gets averaged over the week. So taking a look, if you can remember back to way the start of this pandemic in March of 2020, we were concerned about this bump here and thought this was just horrific, and we were thrilled when it went down. Where we've actually gone up here is considerably higher, but one of the good things is the Provincial Health Office orders to isolate and stay home really have done a trick in pulling it down. There's a slight blip here, which coincides to about a 14-day period after Christmas. So this tells us, well, largely public health measures were successful in reducing the incidence of COVID-19 when we slipped up, and a lot of us saw, limited friends and relatives over Christmas. That did lead to a spike. So it's interesting to compare that and see how we're doing compared to the rest of Canada. And again, from the Center for Disease Control, what we see is we're doing better than the Canadian average. So the measures we do in British Columbia are going well, and we are doing quite a bit better. Ontario and Quebec tend to really skew the average up, but for the most part, we're manageable. If we look at our neighbors in North America, we can take a look at Mexico. And this is a really interesting statistic. When you take a look in the new cases, you can see much more in the rest of Canada than BC. That high spike is due to people socializing over Christmas. And although Mexico is doing fairly well compared to Canada, they are steadily increasing. You'll see that jump really occurs largely when Canadians and Americans go down to Mexico to visit. So if you're thinking about escaping the drudgery of winter and COVID-19 and going to a neighbor to the south, be aware that the influx of visitors is largely correlated to that that increase. And now, you know, the bump here we see at the beginning of December coincides with more visitors. You've likely are running an increased rate to the point now where they're above us. But of course, we can't forget our neighbors directly to the south. And when we look at what their numbers are, it is quite staggering what the US experiences compared to Canada, BC, and Mexico. If anybody has any thought of nipping down to the US to visit or going on to vacation, please think twice. Again, here you can see the what we have noticed with COVID-19 is this bit of a lag here. So these two spikes that you're going to see correspond to Americans getting together for US Thanksgiving in late November, and then Americans getting together in Christmas. And you'll see about a 2 or 3 week spike in COVID-19 cases after those holidays. And of course, down here, this bump is related to Americans getting together for the 4th of July. What that does tell us, though, in looking at COVID-19 statistics, is a large number of the contacts we're getting are more likely in the social sphere and not at work. When people are getting together for holidays, it seems we're getting more COVID transmissions in the home through social connections than we are at work. So that's a good sign that Canadian workplaces are taking appropriate measures. However, we should not be complacent about that. But we just wanted to give this, you know, overview to you. So once again, you know, this is information that's useful. The BC Centre for Disease Control, by the way, has got excellent resources. I just went on this today and downloaded this. You can take a look and pull up any stats. You can also look at particular COVID-19 incident rates by community and by health authority. So for those of you wanting to compare your community to what's going on in you know, another health authority or another part of British Columbia, you can get a look. Ultimately, we are governed by the provincial health officers and what Bonnie Henry says. But you know, this does give us some reassurance that because British Columbians, by and large, are civically oriented and trend to follow public health instructions, it's doing a noticeable job of keeping us safer and healthier than other places in Canada and the US. One of the things that we have to bear in mind is when we're looking at COVID-19 in the workplace is that WorkSafe is an indelible part, an inseparable part of life in a Canadian workspace in British Columbia. They've got some excellent resources on their website, and they've been very good about bringing some guidance. And I'll just ask Claudia to give us a sense of what the COVID-19 rights are at work that we have directed by WorkSafe.
Absolutely. Thank you, Craig. Yes, so of course, employees are entitled to a safe workplace, and employers have a duty to ensure that all employees are safe while at work. So of course, when COVID started last year in March, it brought a whole new perspective, and it brought a whole bunch of new conversations about how people were at risk while at work and what measures could be taken to reduce and minimize that risk. So WorkSafe BC created a policy called the COVID-19 Safety Plan. And the purpose of that policy was to help guide employers in how to create measures and policies at work that would help reduce the risk of employees contracting COVID. Now, the plan has different stages. So, of course, every single workplace is different, and risks will come up in different workplaces in different ways. So the first thing employers have to do is assess the risk. Take a long, hard look at where employees are more at risk while at work, where are employees congregating, what are the tools, machinery, or supplies that employees are sharing, what are the spaces that people are sharing that employers have to pay attention to. And after doing that assessment, WorkSafe BC is asking employers to implement measures that can bring down the risk so that it's as safe as it can possibly be for everybody. So measures are, for example, ensuring that we have signage that reminds people to wash their hands for 20 seconds in the kitchen and in the bathroom, making sure that people have the 6 feet distance between themselves, wherever that's not possible, to bring in plexiglass to create that safety between people. Things like ensuring that there is a maximum amount of people in given areas. Say, for example, in our kitchen, we can do one person at a time in the kitchen, and that kind of thing, putting those kinds of limits. Something that's very important about these measures and these policies is that they have to be communicated not only to management and everybody on the management side, but as well to all employees. So this information has to be posted in the employer's website if they have one, and it has to be communicated through signage, posters, flyers in the workplace. One thing that I also wanted to mention is that the Occupational and Health Committee also has a right to form a part of this conversation in the creation of these policies and measures. And we've put the website here. As Craig mentioned, there's great resources, and you'll be able to find in worksafebc.com, you'll be able to find the COVID plan and the structure for each one of these categories. Okay. So this slide over here talks about the COVID safety plan, and you'll notice also that this PowerPoint here talks about how employers have to continue reviewing and updating their safety plan. So once the safety plan is done, employers are not off the hook. They have to continue assessing, continue monitoring, and continue paying attention to where risk can come up and then addressing that risk in the workplace. Now, of course, if an employee has traveled outside of Canada and they come back, one of the things that employees have to do is they have to make sure that they have policies in place where that employee knows that they have to spend the time isolating and completing their quarantine at home before returning to the workplace. So also, if an employee develops symptoms at work, employers have to have a policy that's well communicated in place so that the employee knows that he or she has to go home and complete their quarantine and isolation and can only come back home once it's safe after a COVID test and after there are no more symptoms. All right. And then also, it's been recommended by Dr. Henry and of course the public health authorities that employees work from home as much as possible. So employers must continue to encourage workers to work from their homes whenever it is possible, unless there is a very specific reason why that can't happen. And in regards to the safety plans, another thing that's important that I touched upon was just trying to avoid people and workers from congregating or crowding in indoor common areas, such as elevators, making sure that you have 2 people per elevator, that there's space designated in the lobby. A lot of people are using signage and stickers on the floor so that we can remind ourselves of giving ourselves that space and not being crowded together.
Thank you, Claudia. One of the other things to remember, of course, is that these are not unilateral employer plans, although there's an obligation on the employer to keep employees safe at work. Work sites do have occupational health and safety committees, and certainly occupational health and safety committees are allowed to look at COVID plans. And if they don't think they're sufficient, bring them forward. What we've seen a number of times is employers in a rush to ensure that the COVID-19 safety plans are implemented is unilaterally publish them. The Occupational Health and Safety Committee certainly has the right to go through and review it. And if you think, for example, the employer hasn't given sufficient weight to the ability to work from home, you can certainly raise that during your OH&S structure. One of the other requirements, by the way, of the COVID-19 plan is that if you're an employer with a website, you've got to make this available on your website so employees can actually find it. COVID plans should be visible and communicated. So it may be that your employer hasn't updated their COVID plan if they've brought it in, or if they have one, it might not be on the website. But two things you can look at.
Could I jump in for a second, Craig? There are a couple of requests to go full screen again on the presentation if you can.
Okay, I'm not.
No, it's stuck in kind of edit mode right now.
Okay, is that better?
Yeah, that's great. Thanks.
Okay, sorry about that. I'm still not quite the PowerPoint whiz that Orion is. Another question that comes up is the ability to refuse unsafe work and when you can refuse unsafe work. The standard provisions of the Workers' Compensation Act and the Occupational Health and Safety regs apply. So first thing you have to do is report the unsafe condition or procedure. Go to your boss or your supervisor. They must do an investigation, then report back to you. If you still think it's unsafe after your supervisor has looked at it, then there has to be an investigation, which has to take place in the presence of the worker and a worker representative of the Joint Occupational Health and Safety Committee. And the investigation doesn't really have any formal boundaries or any formal structure. It's just making sure that the risk is investigated, the threat and the possible alternatives. If there is no safety committee present or you don't have the ability to get a safety rep there, then the worker can choose to have another worker present. So there's an obligation before the worker goes back to work to take this investigation seriously and do it in good faith. And then if you still are unable to resolve that, then you can call in WorkSafe, and a prevention officer will come in and try to find a workable solution. In our experience, the questions that are going to be asked, and if answered yes, it's going to be unlikely that the WorkSafe prevention officer is going to find it's unsafe. First of all, does the employer have a valid COVID safety plan? If they don't have one or it's not up to date, then they'll probably be directed to, the employer will probably be directed to come up with a revised one. Is the employer following public health office advice? Have they decided to, take steps to put in barriers, or have they tried to minimize the number of people congregating in one spot? Have they looked at things like staggering the start and stop times so people aren't all on their break at once or not all showing up and leaving at once? And finally, is the employer providing appropriate personal protective equipment? If the answer is yes to all three of those, it's likely a prevention officer is going to find the work is not unsafe and you don't have a right to refuse. If the answer is no to any of these, the prevention officer will likely side with the employee and put in a directive that they have to get a better safety plan. But just be prepared and forewarned. If you are at the stage where you're refusing to do particular work because it's unsafe, then think about whether or not, what the prevention officer will say when you look at these three factors. Of course, it's not, every situation has to be different, but as a general guidance, these are the three most critical things a WorkSafe prevention officer is going to ask. I'm aware of one case in which workers at worksite had called out actually Transport Canada, because it was a federally regulated worksite, and asked for a determination that work was unsafe because they were working within 6 feet of each other. And the Transport Canada officer said, no, that wasn't a threat because the employer had provided personal protective equipment and hand sanitizer. So simply having to work within 6 feet of somebody, provided there's appropriate personal protective equipment and employers are screening people and doing the health check that they're required to, will not mean it's unsafe work. Christina?
So this one's over to me. So Can you get WorkSafe benefits for COVID? Probably most of you know that WorkSafe provides benefits and compensation for work-related injuries and illnesses, and that also infectious diseases are covered by WorkSafe. So the answer is yes, you can get WorkSafe benefits for COVID. However, not every single COVID-related issue is going to be covered. What is covered is when a worker has COVID and the workplace is at a significantly higher risk for exposure. What's not covered is if a worker does not have COVID or the worker went off work for strictly preventative measures. What this means is that if you've been exposed to COVID but you don't develop COVID symptoms, that won't be approved as a WorkSafe claim. So according to WorkSafe, 50% of all claims that are submitted related to COVID are approved by WorkSafe for benefits, and that includes claims that are suspended or pending. So when you look at only the claims that have been adjudicated, 65% have been approved. And if you remove all the exposure only claims, so those ones that are not covered, 93% of claims are approved. What that means is 93% of people who get COVID and submit a claim to WorkSafe are approved for benefits. So if you need to submit a claim to WorkSafe, you can do that online through the WorkSafe website, or there's the phone number is there on the screen. And you can also download the form from the website or mail or fax it in.
So that's a primer on WorkSafe and some of the rights there. Privacy rights are another significant factors that come in. I'll pass this back to Claudia. This is a question that we don't get as often, but we were getting quite a lot last year.
Absolutely. So, can my boss check my temperature? Now, employees have an expectation of privacy at work. And this expectation of privacy is not absolute in the sense that your employer does have a right to know certain things about you as it relates to work. However, Canadian law has always held that a person's, including of course an employee's personal medical information and medical records, are essential to that person's dignity. So something like taking an employee's temperature is going to be private information. In British Columbia, private information that includes medical information is legislated under the Freedom of Information and Protection of Privacy Act, the FIPA. That is for public sector. And then under the private sector, it's legislated under PIPA, which is the Personal Information Protection Act. And these two acts basically say that an organization such as an employer, regardless of whether it's public or private, will be able to collect a person's private information if it is reasonable within the circumstances. And what that means is that this particular question is not going to have a clear yes or no answer. You're going to have to look at the context of the work environment and the reason of why the employer feels there is a need. So I'd like to give you an example. We have a case here from Quebec. This is a very recent case that dealt with COVID requirements that had been imposed by the employer. This particular case, Teamsters Quebec Local 1999, is dealing with an essential services plant where food is being processed. And the nature of the plant and the way it had been set up did not allow for employees to have the 6 feet distance, and it did not allow for proper physical distancing between employees. So one of the things the employer requested was that when the employees arrived at work in the morning, that they fill out a COVID questionnaire and that they had their temperature taken. So one employee disagreed with this collection of personal information, and she rejected it. She was disciplined, and this proceeded to arbitration. In arbitration, they looked at all of the things that the employer was dealing with, importantly so the fact that employees couldn't be physically distanced from one another. And it was found that in that particular case, it was reasonable for employees to provide their temperature to the employer. Now, of course, the employer, once collecting this information, has to take all kinds of measures to protect that information. But yes, it's not going to be a yes or no answer. It is going to be dependent on the context of your work environment.
So this is continues from what Claudia was just saying. It's this, your COVID test results are also private medical information that normally you wouldn't have to disclose to your employer. But there is a balance between the employer's strong right to privacy, especially around medical information, and the employer's legitimate interests. So there's been many instances where employers have been recognized as being able to access medical information. So for example, employers can generally ask for medical information to ensure an employee's fitness to return to work if they've been away. So for example, if you've been off work because of COVID, you might have to provide a negative test result before you can return. Another example is employers can also generally ask for medical information for the administration of benefits, such as long and short-term disability. So again, if you want to access some short-term disability benefits available through your work because of COVID, you might have to provide a test result that proves you actually have COVID. Employers can also ask for notes if they doubt the truthfulness or quality of medical notes. And they can also ask for medical information to maintain safety of the workplace. When they do legitimately need medical information, they are only entitled to what is reasonably necessary in the circumstances. So for example, going back to returning to work after you've been off, if you've been off work because you've injured your back, that's different than if you've been off because you have COVID. And the employer's need to know information is different. There are a number of cases that recognize the flu as being very serious and deadly enough to justify intruding into employees' rights. And we know that COVID is a lot more serious than the flu. So we expect that it will be easier for employers to justify needing test results. I was able to find one case about the coronavirus specifically, and that's on this slide. And it concerned a care home in Ontario that implemented mandatory COVID testing every 2 weeks by nasal swab. And I don't know if anybody's had to do the nasal swab, but it's horrible. And so this was grieved, and partially because of the invasion into the employees' privacy around their COVID test results. The arbitrator, though, found it was reasonable because COVID is unique and unknown and very damaging, and especially dangerous in care homes. And the arbitrator found that it would not be reasonable to wait for an outbreak to happen at the care home in order to implement testing. So given how deadly and transmissible this virus is and the level of intervention that we've seen from the government to contain it, in many circumstances, employers would probably need to see your COVID results, especially if you work in a high-risk environment such as a healthcare setting, a school, or maybe in customer service.
Okay, thank you. And we'll get to the Employment Standards Act in a little bit, and one of the changes in there. And just to be clear, there's a difference between asking an employee to come up with a medical note to prove that they're off on a COVID-related leave and a requirement to prove that they're free. If you have gone and got a COVID test and have the result, it's going to be reasonable for the employer to ask that. But there are restrictions upon when an employer can ask for a medical note simply because you're off on leave. And that's the Employment Standards Act, which we'll get to. Once your COVID test, though, is produced, and we think it's reasonable that if you've told the employer you're off because you got a positive COVID diagnosis, that you're cleared with a negative result. Not everybody in the organization has a right to know. Most organizations have a dedicated individual, often human resources, one person who will protect the privacy interest. Typically, it's not necessary for direct supervisors to know the result. If you're a large organization, it's appropriate to have one person to verify that there is a negative result. That's, of course, if you've gotten the test. If you've gotten a clearance over the phone because you've been off from work, been isolating for 14 days, and you have a medical doctor give you an all clear, then obviously you don't have a note to produce. And then it would not be, there's nothing for you to produce. If there is a positive outbreak that's work-related, typically the provincial health officers will tell employers when and how to contact trace. Employers if they're aware one of the workers who's attended work at a time when they may be infectious or may be liable to spread COVID-19, you should be encouraging the employer not to try to manage it on their own, but to talk to a provincial health officer. They have a number of risk mitigation tools they look at, and they recognize that by applying a risk-based analysis, there are times when they will advise people to go and get tested, and other times they won't. It's not a determination that the employer should be making. Leave it to the professionals. One of the concerns is if an employer suddenly decides to alert everybody of a potential COVID infection, there's a lot of privacy violations that could occur. Hey, guess what? Claudia's tested positive for COVID-19. You're going to panic on people unnecessarily. And the provincial health officers recognize there's still a significant stigma that can attach to being COVID-19 positive. So for the most part, they'll apply an appropriate framework to do that. You don't have a presumptive right to know the COVID status of your workers, your coworkers. You should assume that if your employer has a policy that requires people, if they've been exposed, to stay home, that people are doing that. Even if you're the Occupational Health and Safety Committee, you don't have a right to get a list of everybody who's been off for COVID. If you have any questions at all or any concern, though, that your employer is not applying appropriate protocols and making determinations on their own, then you should contact your local provincial health office. We do know that there have been a number, particularly in circumstances where workers are working together, where COVID-19 has spread quickly. But provincial health officers take this seriously. There's a lot of contract tracers out there, and they will investigate. Typically, if you are somebody who's COVID-19 positive and the provincial health office is notified, they will not reveal your identity when they do contact tracing. They'll try to, if the provincial health office is doing that tracing, will try to do it in a manner which preserves employee privacy rights as much as possible. So if you have an employer who's trying to manage an outbreak and mitigate this on their own, just politely suggest they leave it to the professionals, because provincial health offices take this seriously. Give the privacy rights at stake. It would only be an issue if you knew somebody who was continuing to report to work knowing they were COVID positive or likely to attend work. In that case, WorkSafe would be probably a quicker option. And if you had somebody who is knowingly positive continuing to work in a manner which would likely expose coworkers, then they could step in. But for the most part, the who gets to know would be limited to your negative test result when you come back after being off positive. I saw one organization that we gave advice to where the directive was, before anybody came back with a COVID, having been off in COVID-19, the COVID test result had to be submitted to HR and to the organization's legal counsel. And we clearly said that was not appropriate. You don't need a lawyer to review a medical note, despite what that law firm might be telling them. So anything beyond one contact person is probably unreasonable, and certainly getting lawyers involved in looking at COVID results is going to be inappropriate. Okay, so we've talked about WorkSafe, we've talked about privacy implications, but COVID-19 permeates all of society, including the home. So maybe I'll throw this over to Christina and say, look, how do you protect your family if you're concerned about a COVID exposure? Sorry, Christina, you're on mute.
Sorry, I muted because there was some noise in my neighborhood. Okay, so what you have up on the screen there is Section 3 of the Human Rights Code in BC, which says that people cannot be discriminated against because of family status, and that they're entitled to accommodation, in short. So if you live with someone who is vulnerable, are you entitled to accommodation under the Human Rights Code? And unfortunately, there's not a very clear answer to this. But it's still a murky area of law and may require a little bit more litigation. So it is clear that you can't be disciplined or treated adversely because of your spouse or your child, but it's less clear what accommodations are required because of your spouse or child. and it's pretty unlikely that you would be entitled to accommodation because of a roommate or a non-family member with whom you live. The leading case in BC is a 2004 Court of Appeal case, which I've put up on the slide. And in that case, an employer changed the shift of a mother who had a son with special needs. The court found the employer had to accommodate the mother's duty to her son, and that the shift change was discriminatory. The court said family status will be engaged when the employer imposes a change to a term or condition of employment, which results in a serious interference with a substantial family duty or obligation. Although this case was successful for that mother, the test is actually quite a high bar for employees to meet. And for this reason, that case has been widely criticized as not providing enough protection for families. But there's still a very lively debate at the Human Rights Tribunal about how to apply it. So for example, the Human Rights Tribunal has found that the code not only applies to changes that the employer makes, but when other circumstances change. The important part is that there's a serious interference with a substantial family duty. We've said a lot today. The pandemic is very special and unique. Obviously, it's a big change, and that's affected employment. That BC Court of Appeal decision paid particular attention to the fact that the son had special medical requirements that the mother had to attend to. So there is a possibility that an employer could use the same reasoning now under COVID. That is, we know people with pre-existing conditions or who are older are at a much higher risk to develop serious complications or even die from COVID. So an employee may be able to argue that they have a substantial duty to this family member to not expose them to COVID, and then an employer's decision to not accommodate would be a substantial interference. So the law on this is a little bit tough, but given the severe potential effects the infection would have on vulnerable people, the door is open for employees to make requests for accommodations if they live with vulnerable people, and hopefully get an accommodation like working from home or something like that would help reduce the risk to the other people that live in their household.
Thanks, Christina. So, I mean, I think just to echo that, yes, the way the law is right now, people have widely criticized BC for being behind the rest of the country when it comes to accommodation and family status. Personally, I think that a grievance went forward, citing a human rights ground, because the employer did not accommodate the request of a worker to work from home when they had a family member who was vulnerable or more likely to contract COVID-19, or the consequences would be much more severe, i.e. somebody with a compromised immune system, a chronic health condition, or somebody who was over 65 would be a good case to take forward. The fact that the law isn't clear on this, certainly doesn't prevent anybody from coming forward. The unions that accept the law as it is don't change anything. Ones that push it make new law. If you're in that situation, I think this is an area in which would be a good chance to push, the human rights laws in British Columbia to be a bit more engaging of family status, where we're lacking behind, and particularly because I think by and large we have seen, certainly in my field in law, we thought forever that working remotely would not work, or doing arbitrations via video would never work. And we've seen, despite our preconceptions, for the most part, there's been a lot of success. We're actually getting arbitrations done quicker and more cost effectively. So I think this is an area in which a union would be well served to push forward and challenge some of the law. So the sort of things lawyers love to hear. Difficult case, chance to push the law. Let's go for it. So if I am working from home, though, do I have any rights? Like, how does a collective agreement apply? What does the employer have to do? Claudia?
Yeah. Yes, the collective agreement still applies, and you are basically entitled to all of the rights that you are entitled to at work. Those rights come with you at home. Now, WorkSafe BC again has developed policies and guidelines of, what is this going to look like for an employee? And this is going to involve making sure that your ergonomic needs are being satisfied. So for example, if you are someone who works, sitting down for most of the day, and if you had an ergonomic chair at work, people are being allowed to bring those chairs with them. Any kind of equipment that you had in your workspace that helps you with anything like carpal tunnel, anything that you need ergonomically, your employer has a duty to make sure that those things are provided to you at work, and that that you don't miss out on those needs. And we've given you the WorkSafe BC website there if you want to take a look at what the guideline actually spells out. But yes, absolutely, the collective agreement still applies. You bring those rights with you from the workplace into your home, and the employer has a duty to make sure that you have everything that you need to do your job properly from home.
So Claudia, if I have an employee who's working from home and they don't have a decent webcam, can I tell them they can only work from home if they go out and buy a new webcam?
You got to send it to them, Craig. You got to send them the webcam.
All right. So another question that comes, do I get paid if I stay home? Largely, this has to do with your collective agreements. Certainly, we know that if you get COVID-19 at the workplace, WorkSafe will treat this as a compensable injury. If you can't prove that it's at the work site, but you do have COVID-19, you're likely going to qualify for benefits under your short-term disability plan. However, if you don't have COVID-19 and it's a requirement by the provincial health officer to stay home and self-isolated, you're likely not going to be covered, we found, by most short-term indemnity plans because you're not actually sick. So most of the short-term plans will require a diagnosis of illness, but it may be reasonable if you've got short-term or sick leave that's provided by the employer to actually get it. Now, if the employer tells you to stay home, even after the provincial health office clears you, you're likely going to have a grievance, and that's not allowed. We have some employers who say if you've been exposed to COVID-19 or you've got a potential exposure, you still have to stay home for 14 days and self-isolate. In that case, so if you've talked to a provincial health officer or public health nurse and they've given you the clearance, then in our view, there's a grievance if you're told to stay home on unpaid leave. Anybody who has been cleared to return to work and who isn't being allowed to return because the employer is applying a higher standard should be entitled to paid leave. So I'd encourage you to file a grievance under that basis. If the employer is being overly cautious, above and beyond what public health says, then you should be reviewing that. Similarly, if you get a negative COVID test, we know public health will clear you to return to work. The employer can't require you to continue to isolate and keep you off work unpaid. Not everybody is aware of this, so it's really worth taking a look at a new section of the Employment Standards Act, Section 52. If you request leave, you're entitled to unpaid leave for the period described in relation to COVID-19. If you've been diagnosed with COVID-19 and are acting in accordance with the instructions of a medical health officer or the advice of a medical practitioner, so you're following what they say, you're allowed, your employer can't require you to go to work. We haven't really heard any cases where an employer was saying, show up to work even if you're COVID-19 positive. Often it's employers being overly cautious and requiring people to stay off work when they don't have a diagnosis or or just to run out the whole 14-day period. If the employee is in quarantine or self-isolation in accordance with the provincial health officer, the Quarantine Act, the guidelines of the BC Centre for Disease Control, the guidelines of the Public Health Agency. So again, you're entitled to be away on unpaid leave. Presumptively, if you're following the orders, and we say the flip side is true, if you're cleared to return to work, you should be allowed to return to work. So this is the gray area, though, that what happens if you're not actually ill, but you're in quarantine. Typically, as I said, your short-term disability plan won't cover that. For those of you, though, that are coming up to collective bargaining, it's worth making a note of. It's something nobody thought of when you're bargaining, but it's a good thing to keep in mind with your next collective agreement, that you get short-term disability benefits if you're ill or following a public health direction to stay away. One of those things, who would have ever thought you would need to negotiate in your collective agreement a provision to stay home to get paid and qualify for sick leave when you're following a public health order. But I fear that this won't be the last time Canadian workplaces are hit with a pandemic. I think the way, just the nature of the world, we're getting more crowded, we're getting a lot more interaction. In the foreseeable future, we will have another pandemic. It may be similar to this, but a thing to bear in mind and put on your radar when you're going to bargaining, turn your mind to benefits and pay for people who are quarantining and self-isolating, even if not sick. One of the challenges of COVID is when we have employees that get paid for being COVID positive, but not getting paid if they're being quarantined, that leads people to show up to work. So ultimately, everybody is better served if people who are told to quarantine or self-isolate are staying home and getting paid as opposed to coming to work before they should. The employer, if the employer has directed you not to return to work, then they obviously have to give you unpaid leave. And the employer is providing care to an eligible person, including because of the closure of a daycare or school, they have to give you unpaid leave. So you can't be required to show up to work. It seems a little odd that the employer would ever tell you you can't have unpaid leave because they're concerned about your exposure. But there is a provision that says they can't require you to show up to work if they're concerned about your exposure. And you also do have a protection if you're providing care to an eligible person because of the closure of a school or daycare. As Christina said, though, that's a different standard from taking a positive step to provide you the ability to work from home. And I think, the provisions of 52(2)(e) here, or D here, which says you're entitled to leave to provide care to an eligible person, is meant to deal with those 1 or 2 day one-offs when the person is sick. If you have a long-term issue, though, where you had to provide care to somebody who's immunocompromised or had a chronic disease, then I think you would still be entitled to the protection of the Human Rights Act. And if the employee is out of the province and can't return to the BC because of the travel or border restrictions, if you did decide to go off to Las Vegas and can't make it back, whether or not that's a smart thing to do, the employer can't deny you leave because you can't come back and you're following those restrictions. So the employee is entitled to this as long as this applies to the employee, so it can continue. Now, 4 and 5 are the bit of a tricky one. If requested by the employee must, as soon as practical, provide to the employer reasonably sufficient proof that a circumstance in subsection 2 applies. So that would be demonstrating that you have a family member or a child that you're looking after or who's carrier in. But the employer may not request, an employee is not required to provide a note from a medical practitioner or registered nurse for the purpose of subsection 4. So the employer can't say you only get to stay off with leave if you provide a medical note to the effect that you're staying home to care for, a family member or a child that you can't otherwise look after because they're away from work, school. Similarly, they can't ask you to prove through a medical note or registered nurse or nurse practitioner that you're actually under a quarantine order. So they can't make, and of course there's a good common sense reason for that. That is to prevent, putting undue care on the healthcare system. So you can't require an employee to provide a note in order to be off. However, if somebody has been off, it is appropriate to ask for a negative COVID-19 test on a return to work. But to be clear, the employer can't say you can only stay off with a medical note. So be aware that the employers that say you must provide this, you've got a protection under the Employment Standards Act. So I'm sure a lot of people who have kicking around their union office or on their computer an older version of the Employment Standards Act. This was amended last year. So make sure you go to the Employment Standards branch website or bclaws.ca and download the latest copy. We just put this up here because people know that there's some sort of right out there, but they don't often know where to look. And it's not necessarily automatic that you would think to look at the Employment Standards Act, but it's a good resource and everybody should review that. It would be a good thing, for example, for an occupational health and safety committee to look at when you look at the employer's COVID-19 plan. How does the COVID-19 plan align with the Employment Standards Act? So it'd be reasonable for a health and safety committee to say, the COVID-19 plan at my work site should include a reference to section 52(5) of the Employment Standards Act that an employee does not have to provide a medical note when they're going off on COVID-19 leave. So just one of the things, it's worth doing. Look at look at the Workers' Compensation Board resources and what should be in a COVID plan, and make sure that you're getting the benefit of all the protections under the Employment Standards Act. So one of the interesting things that we have seen in the news in the last week is off-duty conduct and what people do away from the work site. So I guess, Christina, like if you're speaking out and commenting on COVID and COVID-related issues, like thinking that COVID-19 is a conspiracy, can you ever be disciplined by your employer? Can your employer say anything about that?
Yeah, I might have only been doing this law thing for less than a year, but I'm going to give you the perfect lawyer answer, which is that it depends. So the short answer, even the shorter answer, is that yes, your employer can discipline you, but it depends. So every employment contract includes an implied duty of loyalty and fidelity from the employee to the employer. And what that means is employees must act in the best interest of their employer and should not do things that harm the employer's interests. So, and that extends to comments and actions made outside of work, such as on Facebook or if you attend a rally. The Supreme Court has found that publicly speaking out against your employer can breach this duty and can be grounds for discipline. But it's also not an absolute prohibition on criticizing your employer or speaking out on public matters, and it really depends on the circumstances. So, for example, there might be a higher duty on public employees who are criticizing government policy. There's a big difference between a grocery store clerk who thinks that Dr. Henry should be taking more strict actions against restaurants and pubs, or someone who works in the public health office making the exact same comments. That person who works in the public health office has to be careful to not undermine their employer's interests. It also matters how something was said. Was it said respectfully or was it said maliciously? Whether it's a topic of public debate or whether the employer was singled out by the comment or a client of the employer was singled out by the client or by the employee. Or for example, whether the comment was a spur of the moment type of comment, or was it a long and drawn out and going over a period of time. So in the context of COVID, given the high level of public concern, employees should be careful that their comments don't harm their employer, which includes attracting negative attention to their employer based on their comments. So it's not on the slide. Oh, the slide that I listed there is the Supreme Court case that said that it was okay to discipline for speaking out against your employer. And I actually found also a 2021 case in Ontario. And in this case, I'll put it in the comments for people. In this case, it was an employee who worked at a hospital, but not in healthcare. And he shared a video of his work site with the media, and he did it anonymously. The employer was able to find out that it was this particular employee who shared the video and disciplined him for it. The arbitrator found that while there may be instances where an employer should be exposed, in this case, the information was used to paint a misleading or inaccurate picture of the hospital and was designed to embarrass the hospital and undercut its authority. And so the suspension was upheld. The bottom line is that you shouldn't be speaking up publicly against your employer, and the best course of action is to not name your employer when you do say something. And you should always ensure that if you are saying something, you're not attempting to embarrass or undermine your employer with those comments.
Thank you, Christina. So an important thing to recognize about Fraser, that is a case where the employee was a member of the public service and said something publicly and identified themselves as an employee. If you are an employee and saying things on your closed Facebook group to your friends, that's likely not going to be something the employer can discipline you for. If you're saying something in an open forum, like commenting upon Vancouver Sun or Vancouver Province article, putting your name up and saying, I'm an employee of this employer, and everybody should know this employer doesn't care about people's health and safety, and it's identifying the employer, identifying yourself as an employee, and being reckless as to the truth of the comments, or taking something out of context, there's likely going to be some recognition that there can be a discipline. The circumstances in which you might be permitted, if you're a member of a union executive and the union has repeatedly tried to raise a health and safety concern, say, for example, you're an executive member of a union Your union deals with the public on a regular basis. You've been pushing and pressuring your employer to come up with a mask policy. Your employer says, yep, you can have all the masks you want. We're just not going to provide them. And as a result, your members feel that their health and safety is risked. If it was a case where you brought that up internally with the employer, there's been no resolution, and you're sort of doing an appeal to the public to let them know about this. You're acting in good faith. You're acting, reasonably after you've given the employer a chance to address it internally. Then you're probably immune from discipline. It's always a bit of a gamble because despite what the rules are, employers tend to overreact, some much more than others when they see their name or hear their name in the press, and do all sorts of things that are over the top. Certainly, if you, as a union, it's far better that somebody who is speaking and being critical of the employer does so after they've attempted to address the matter internally and tried to raise this with the employer. They do so in their capacity and make it clear they're doing so as a member of the union and is not an employee, and they have their support of their union. You don't want somebody running off and saying, I'm a shop steward and I'm speaking for the union, when you've never addressed that with the union executive. There are times and places to bring things forward. And with COVID-19 especially, one of the things an employer would look to discipline for is whether or not this has been addressed in-house appropriately. So we can go on and on about the law of whistleblowing, but it's certainly something you would want to ensure that you're proceeding with, not rashly or reactively, but only as sort of a last resort if you thought the need was there. It's always a good idea to tell your members that when they are commenting and talking about the employer, to always use a closed Facebook group. And it's always a good idea to not put where you work if you're going to be commenting and discussing the employer. If it's sort of discussions within a closed group, it's better just to keep that in person. If you must, then try to talk about your employer and not Safeway or actually the name of it. But yes, if you're speaking out in COVID in a manner which damages the employer's interest, there could be. What if I break the travel ban? Well, interestingly enough, before we set this, we didn't have the remarkable case of the Gateway Casino executive. If you break the travel ban, look, your employer can require you to self-isolate for 14 days. It can be without pay. If you've decided you've gone to another province to go skiing, or if you've gone to the US to go shopping, it is reasonable for them to say, yes, you have to self-isolate until you get a clearance from a provincial health officer. If your conduct is high profile, though, and you are identified as an employee of your employer and your conduct calls into question its reputation, you can be disciplined. So we all have heard by this point of the Gateway Casino executive, and I can't help but think there's some degree of karma here for the position Gateway Casinos took with the BCGEU, taking an unreasonable position, making them go out on a multi-month strike in order just to get something shortly above minimum wage. It gives you an indication what employers are dealing with. These are the a casino executive and his partner who figured they would fly up to the Yukon and pretend to be local workers at a hotel in the remote part of the Yukon to jump the vaccination queue. They were foolish enough then to ask a ride back to the airport, which kind of led people to question whether or not they were really local hotel workers as claimed. Then they jumped back in their chartered jet, and it occurred to the locals that you're probably not working up in a motel in the Yukon if you can afford a jet. Certainly something like that would be seen as bringing the organization into disrepute. Hopefully most workers are smart enough not to do that and will respect the queue. You've certainly seen cases where public elected officials have resigned because they failed to follow the travel ban. If you're simply a warehouse worker, who has gone to the US to visit a relative, you tell the employer at the end of the trip that you broke the travel ban. You're probably not going to be disciplined for that. You'll be required to stay home, but that on itself is probably not worthy of discipline. If it's high profile though, particularly, and it's unfortunate, but we always find that healthcare professionals and for some reason teachers often get held to a higher standard. If you're one of those groups, because healthcare professionals and again teachers, although it's unfair, are seen to be held to a higher standard because they're seen as role models. If you're in one of those professions and had a high-profile breach of the travel order, then it may be possible that you would be likely submitted to discipline. I think a termination for a unionized employee would be excessive, but I think particularly if you're in healthcare, there may be some interest in the employer of saying employees that don't follow the public health recommendations should at least be subject to a reprimand. As far as we know, we haven't heard of any unionized employees being disciplined for breaking the travel ban. We have heard about them being required to stay home for 14 days on unpaid leave, which quite frankly is more of a hit to them and more of a punishment than getting a warning letter. And certainly being told they're not going to be able to show up to work and won't get paid for the next week has been appropriate. And we don't see a lot of breaking of the travel ban. But again, it really comes down to what does that say about the employer? And the unfortunate reality of arbitration in today's day and age is that arbitrators will give some weight to that. You shouldn't think that something that occurs outside of work would have any business of the employer. But unfortunately, there are enough cases that talk about the reputation. So if you're asked, for advice from a member of the union, should they go? I'd suggest no. If you do find out that they've gone out of town or in breach of the travel order, suggest they tell the employer as opposed to having them find out on their own. And obviously, don't put photos of yourself breaking the travel ban on the breach in Mexico on your Facebook. Last but not least, the area we want to talk about is what happens when we finally get the vaccines. We're all looking forward to that day when we can put our masks away and start mingling and socializing with our coworkers. We do know that you shouldn't impersonate hotel workers up in the Yukon and try to misrepresent yourself to jump to the front of the queue. But while some people are happy to get vaccinated, other people have legitimate concerns and reasons for not getting vaccinated. Claudia?
Yeah, so as Craig mentioned, a lot of people are really looking forward to getting those vaccines. A lot of people are not. And we have different phases when they're going to start rolling out those vaccines. They already started. People have started, going online to check and see when is it that I'm going to get it. But it is an important question that has been coming up. Can my boss force me to get vaccinated? Now, the legal foundation that we have in Canada is very likely not going to allow your employer to force you to get the vaccine. There are a lot of people who already decide not to get vaccinated for religious beliefs or because of their own medical circumstances. And there's already a lot of people in Canada who opt out of certain medical treatments, again, because of their religious beliefs or because of their medical conditions. Dr. Bonnie Henry said recently, we have no mandatory immunization programs in this country and in this province, and we do not expect COVID immunization will be mandatory either. That being said, as we have alluded throughout the course of this presentation, COVID has taken the world by surprise. It's taken Canada, our healthcare system, our communities, all of us by surprise. And whether or not the law might change or circumstances may change in the future is going to depend on the severity of the pandemic, how it continues to develop, and how it continues to affect our communities.
It's a bit of a two-edged sword there. So while your employer can't force you to take a vaccination, they can take action if you refuse a reasonable vaccination request. And one of the cases, unfortunately, the leading case on this is Interior Health Authority versus the BC Nurses Union, a case from 2006, when nurses decided that they were going to refuse to get vaccinated for the flu. I won't tell you who counsel was, but it was one of the few cases I didn't win. And the employer was found to have a reasonable policy that said, if you are a nurse working with high vulnerable groups, i.e. in long-term care homes, you can, we can require, in order you to attend work, to take appropriate prophylactic measures, which are either taking Tamiflu, which is an anti-flu retroviral, or getting the vaccine. I think much more so than now, about 15 years ago, there was much more concern about vaccination. And there were legitimate reasons why people, as a matter of conscience, didn't want to take it. And their view was, why don't we wait and see? And if I'm working in a facility where the flu hits, I'll then take the vaccine. And the employer said, no, that's not reasonable because of the incubation period. You know, if you are refusing to take the vaccine and you don't have a legitimate medical reason, it's just a matter of conscience or disagreement, then you'll stay home on unpaid leave. There are people who, for example, because the flu vaccine is incubated in an egg culture, there were people that had egg allergies, which were allowed not to take the vaccine. If there was a valid medical reason for not getting vaccinated, then the employer accommodated them. But an employee who, for the you know, for the sake of just wanting to have a philosophical objection, and you know, there's some understanding about this. You know, why should the employer get to tell me I've got to put foreign biological material in my body? Didn't want that. Ultimately, the decision was that it was reasonable precaution to protect the vulnerable. Likely, if this were applied today, it would be that people in a healthcare scenario who refuse to take the vaccine would probably be required to be on unpaid leave until such time as the pandemic or the provincial health directive was, state of emergency was over. There's a lot of good reason, you know, why it makes sense from a public policy perspective. I don't think the law is advanced or at the point now where you could get terminated or your employment would be, you know, eliminated. But this does stand for the proposition that certainly healthcare employees who don't have a valid reason for taking a medically accepted and proven, they call it a prophylactic, would be required to stay home from work. Now, I should point out, one of the reasons why the Interior Health Authority succeeded was there is an excellent witness that they had that came in and explained the flu. And I'll just, it would be a, you know, a webinar with lawyers if I didn't digress and do one little war story. If you've ever done a case as a lawyer in which you're trying to challenge an expert, there are a variety of tactics we try. You try to get the opposing expert to overstate their reputation, overstate their training, to exaggerate the symptoms, to generalize, to, you know, extrapolate, to hypothesize, to go anything beyond the facts in order to impeach their credibility. And this witness was the worst. This witness that I had for the Interior Health Authority that I was trying to cross-examine would not do any of that. This witness would not exaggerate. This witness would not overstate their, you know, qualifications. They would not manipulate the facts. I couldn't do anything to impeach their credibility. Fortunately or unfortunately, you know, the Interior Health Authority's policy was won. And this witness remains one of the very few who I've just sit back and think that was an amazing witness. I wish every expert would be like that. And that's the last time I ever want to try to cross-examine Dr. Bonnie Henry. So we've given you a bit of a tour of COVID-19 from our legal perspective, touched on some of the issues and questions that we typically get asked. You now have the opportunity, and Orion, I'll leave it to you to figure out how we're going to actually facilitate it. If you want to pick questions and fire them off to us, I'll leave it to you to facilitate, but I think we can open up the floor, so to speak. I think you're on mute.
Sorry, Craig. Sorry, Craig.
It wouldn't be a Zoom without somebody being on mute.
Yeah, exactly. Probably when you have two mutes, you have one on your computer and when you have your thing. If you actually drop your screen sharing, Craig, that way everybody can see your face. Our face is bigger. I was just laughing. I think you had the best Harrison story so far with your Bonnie Henry story. So that's how you set it up was very good. 10 out of 10. So quickly, for folks working in the federal jurisdiction, health, we have these provincial WorkSafe frameworks. Are you aware of anything in the guidelines in the federal workplaces?
Yeah, typically the federal workplaces, you're going to look at the PHAC, the Public Health Agency of Canada, and for the most part, those have been set out. Those are federal guidance points. Typically, you'll see that the BC Centre for Disease Control will follow PHAC. And they have set out the regulations. So what you're looking at is the Public Health Agency of Canada, and that's going to have resources from the Chief Public Health Officer of Canada, and they've got information there that regulates federal work sites, such as the transportation industry, banks, telecommunications.
Okay, great, thanks. Next, so you're working from home directive. Can your employer dictate where you live/work when you're under such a work from home agreement?
Anyone? Claudia?
No.
I agree.
Okay, I've never heard a lawyer give such a short, straightforward answer, so I was just a bit stunned there. So, okay. So we have kind of two questions on kind of accommodation. So one is if you're autoimmune compromised and you can't work from home, what options do you have? And the other one also kind of similar related is somebody's over 65 and they feel that puts them at a greater risk of COVID. Kind of what's the accommodation requirement there? So again, autoimmune, work from home is not possible, and the other one is over 65. Would that be considered a risk factor requiring accommodation?
Well, I'm always hesitant to think that just because somebody is over 65, that they're in a different category. I mean, there's a lot of really active, vibrant people who are, in their late 60s that are, in better shape than their younger coworkers. But the reality is that group has been identified as higher risk. And if somebody is in that group, then there should be a right to accommodation. Even though the particular workplace might not, extend accommodation, one of the interesting things is the British Columbia government about 9 years ago eliminated age as a restricted ground for discrimination. It used to be that you could discriminate against employees age 65 and older. Of course, when the mandatory retirement was eliminated, that removed that restriction. So if the effect of the employer's position is you don't get the benefit of something that the provincial health office has said should be taken into account, I think there would be a human rights basis to argue you're being discriminated against on the basis of your age. In that provincial health office says people over age 65 are more vulnerable. If the employer isn't giving you the benefit or extending the ability to extend from home because you're, a high risk group, I think you would have a valid basis to do that. Of course, it depends on the work site, but I would think, you would have a greater claim to your, looking at work from home than another coworker. The immunocompromised employee is a far, far different story because, I would think that with some really, creative thought, there should be an ability to accommodate you, even if it's not working from home. You know, is there an appropriate protection that you could put in place by working different hours or minimizing your contact? Ultimately, it probably would be considered an undue hardship if you couldn't work at all due to a compromised immune system. And I don't think the employer, for example, is required to pay you full-time leave if you're unable to do any work. Again, I don't know enough about the work site, but my view would be that if you're unable to do your job because of your medical condition, then your employer should be working with you to at least get you short-term disability payments. You know, if it's simply a refusal to, you know, contemplate, you know, whether or not you can work from home or do your job remotely, that should be investigated. If you, you know, had a job, say you're a correctional officer, which, you know, you're just not going to avoid being in a scenario where you're going to be in touch or in contact with people, then, you know, that would be appropriate to get you on some sort of disability payments. But without knowing the details of that, I can't really go further, but a refusal to look at any accommodation would be unreasonable. But ultimately, if you can't due to a medical condition, then at the very least you would be entitled to disability payments.
Okay. So somebody just has a follow-up question on undermining employer in the public. And I think you touched on it a little bit. So a union rep, and I'm assuming they don't mean a full-time union staff person because they would be working for the union, but like the president. So I think you kind of covered it, but like reports to board of governors example they bring up here. So is there anything those people should be careful about if you're like a union leader beyond what you said? I think you said make sure you're saying it as a union leader, not as an employee, but anything else?
Sorry, what was the context of that? I didn't quite catch that. If you're
is the obligation not to undermine employers different for union reps? Our work implicitly criticizes the employer all the time, and sometimes it's public or quasi-public, such as reports to board of governors.
Well, I mean, I think, you know, that's really within the scope of what a union rep is doing. I mean, if you're in a post-secondary education, and part of I honestly think every context is everything. I think certainly academic institutions and post-secondary institutions have a higher threshold for, you know, the free market of ideas. And I think, you know, discourse is much more accepted and criticism in a post-secondary education system. I think if you're talking about a university or a college, and part of the dialogue of the workplace is regularly questioning, you know, in a collegial governance model, what the employer is doing, and you're not exceeding the bounds, then I don't think they could crack down on you simply because it's COVID. It's sometimes a different universe dealing with labor relations in a post-secondary education. You know, you've got this collegial governance model, a dialogue is open. I think if you were respectfully being critical of the employer's COVID-19 problems and processes in the same manner that you would address a funding or a budget cut or a failure to fill, you know, positions with tenured professors and a high use of sessionals, and that's part of the regular critique in the workplace, then I don't think you're liable for any special discipline. So if it's status quo, I think you're okay.
So when it comes to kind of, so I read the question verbatim, to what extent is it appropriate to involve a union representative in identifying exposure risks from a specific instance of confirmed COVID positivity?
It's hard to say. It would be appropriate to have that union rep bring that forward to management and find out what they are doing with it. In my view, if the employer has contacted the provincial health office and is following their advice, the union probably doesn't need to be involved. I think the union can be involved to the extent to confirm that the employer is taking appropriate steps, but there's a you know, there's a lot that we don't know about in terms of the considerations that go in and a lot of the risk factors that are being analyzed. And the challenge is to really know in what circumstance contact tracing is appropriate, or what, when other people have to be isolated really involves a lot of personal information. So if you're getting the union involved in finding out why the employer, why provincial health is doing certain things, you necessarily have to get a lot of personal and private information. I think the union rep should be involved in investigating an exposure if the employer says, don't worry, we know what we're doing. I read a pamphlet on COVID last year, or I looked at a website. Then it's appropriate for the union to get involved. I think it's appropriate for the union to contact provincial health and confirm if they're not following it. But in my view, just because of the significant privacy rights that get involved, you're not looking at just what this employee did at the workplace, but you're having to figure out and find out what the employer's home life is, what they do off duty. Provided public health is looking at it, I don't think it's appropriate. I think the union certainly, though, should be involved in the COVID plans. And part of that COVID plan should be ensuring that if there's a COVID related exposure at the workplace, the employer is acting pursuant to public health guidance.
So we have quite a few questions here. So I think we'll probably do it for another, if it's okay with you, Craig, about 10 minutes, and then I think we'll have to cut it short. Unless you want to stay all night, it's up to you. Going back to the work from home question, and so a couple working from home questions. So follow up is, in that case, the employer is claiming that if you leave BC, WorkSafe might not cover you. And the other question to kind of WorkSafe claim is, are you covered from working from home? So if you trip or you have some injury at home, is that a WorkSafe claim?
Claudia, I'll give you a chance to answer this. You're our WorkSafe expert.
Yeah, tackling the, if something happens to you at home while you're working from home, WorkSafe would definitely cover you, because remember, you're taking those rights from work and bringing those rights at home. Now, there's going to be, questions that they might ask you in regards to exactly what you were doing, and, just being able to describe what it is that you were doing at home when you fell. But yes, you should be able to get coverage from WorkSafe BC. Now, the other question was a really interesting one, and connected to that one asked at the beginning about whether you can move and whether your employer has a say. But this time they're bringing it within the context of a WorkSafe BC claim. And what do you think, Craig, like in terms of coverage when you're working from home outside of the province?
Well, I think the Workers' Compensation Board, WorkSafe BC, is going to look at where your place of employment is. So if normally your employer is registered with WorkSafe, and they're paying premiums based on you being an employee there, the fact that you might live out of province and are working out of province doesn't disentitle you to WorkSafe coverage. If you are performing work for the benefit of an employer based in British Columbia who is registered and paying premiums, the fact that you might be out of province won't disentitle you. So for example, if I'm working in British Columbia and my employer is in British Columbia, but one day I have to go to Alberta and to visit a work site, say I'm involved in the mining industry, and I have a trip to a work site in the course of my employment, I get injured in Alberta, I still get covered by WorkSafe. So as long as my employer is based in British Columbia and I'm doing work for the benefit of my employer based in BC and they're paying premiums, I think you would still be covered even if the work from home occurs outside of the province.
Okay, thanks. Of course, quite a few questions about mandatory vaccines and stuff, so I'll kind of lump them a little bit all together. So one is, you kind of already mentioned healthcare as a likely possibility of a likely mandatory. What about places like restaurant, casinos that are currently closed? Also, fire service, paramedics, those sort of folks. And follow up: if you refuse to get vaccinated, could the employer require you to follow more more stringent kind of requirements than your coworkers who have been vaccinated?
Again, depends on the scenario. I don't think, let's take the, the environments in which we know that protective measures are working, casinos and restaurants. I think it would be reasonable to say, look, you can't require somebody to get vaccinated. They don't have the same level of contact in a casino or in a restaurant as a first responder does. Simply because I think being a first responder, fire or ambulance attendant is a lot more unpredictable. I think it'd be reasonable to require them to be vaccinated. Simply, it's different than the flu. I mean, we know people die from COVID. If you're a first responder, then I think a requirement to be vaccinated is going to be reasonable. Taking more stringent protections, I mean, I think it would be okay if the employer said those that don't get vaccinated still should wear a mask. But if your employer was a restaurant and said, no, we just like we'd like to be able to tell everybody we've all been vaccinated. It's a good business reason for us. We know from just looking at exposure patterns, there's very little or almost negligible transmission of COVID in restaurants. By and large, the people that work in restaurants and run and manage restaurants are being very, very good about their, safety plans. I thought the real weird question would be if teachers have to be vaccinated. That's something I was worried about. But education is a completely, again, another different, a different animal. So long and short, no, I don't think if you're not in a job where there's going to be a high risk or high consequence of transmission, they can require you to be vaccinated. But I would expect that the employer and the union in a work site like fire fire services would have that discussion, and maybe an appropriate accommodation if somebody could not get vaccinated would be a job that doesn't involve interacting with the public until as long as the emergency, provincial health emergency is continuing.
Okay. So I'm going to do 3 more questions, then I'll cut it off. So this one, I've heard it come up a few times. So it's for folks who have kind of anxiety, mental health concerns, and they're very concerned about coming back to work in the office, even with protocols and PPE in place. Even despite those assurances, they're still having anxiety disorders. Is there a duty to accommodate issue there?
Christina, do you want to?
I'll take a swing at it.
Okay.
Yeah, the anxiety and other mental health issues are recognized under the Human Rights Code as disabilities requiring accommodation. And as Craig mentioned earlier, the accommodation is to the point of undue hardship. And so really the question is, does the employee have a quote unquote real illness that would fall under the Human Rights Code, which anxiety normally would? And what does the employer have to do in order to accommodate them to the point of undue hardship? Maybe I'll pass it over to Claudia or Craig to take it from there.
I'll just jump in right before Craig expounds on it, that, what's going to be really important here is for the employer to give you the opportunity for the employee to tell them what they need to be accommodated at work, and the employee will also have, a duty to communicate what accommodations the employee needs at work. Because if you don't provide those details, that might come back and harm you afterwards. So definitely, as Christina said, the employer is going to have a duty to accommodate. In this case, it's the anxiety that's being triggered by the pandemic that is the disability, and the employer is going to have to give you an opportunity for you to tell them what you need in order to be accommodated up to the point of undue hardship.
Yeah, and I would expect in a case like this, it's reasonable for the employer to say if you've got a mental health or anxiety issue, that you're under the care and treatment of an appropriate medical professional, whether a psychiatrist or a psychologist, and that you have a treatment plan which looks to reintegrate you into the workforce. It's not simply enough to say I've got a mental health issue, but if you can say, here's my treating, I'm currently seeing somebody for this, And I've got a plan that will reintegrate me into the workplace over the next 6 months. It's going to be a graduated return to work, or it's going to be some milestones, ensuring that, we've gone a month without a COVID infection in the work site, or taking appropriate precautions. In as much as there's a duty to accommodate, there's also a duty to facilitate and cooperate. And part of, I think, a reasonable accommodation would include just a commitment by the employee to continue to see a healthcare professional. Mental health is really no different than physical health. If you were off with a physical disability, you'd be expected to be under the care and treatment of a professional and be following a treatment plan. Same thing with mental health. That being said, I don't think the employer is entitled to all the details, but merely confirmation that you've got a condition which requires accommodation, that you're taking steps to have it treated.
Thanks. So I know this is probably a pretty specific and might depend on the situation, but if a collective agreement has paid quarantine leave, do you think an employee could and should access it for 14-day self-isolation if they traveled on a vacation against public health officer orders?
Depends on the collective agreement language, but this sometimes comes up in collective agreements that have paid medical leave. And one of the questions, which I think is now might not be intuitive, but has been answered largely in the positive, is, what if you decide to go and get surgery? Say you want, cosmetic surgery, and you decide to get, a nose job. Are you entitled to leave, a medical leave, if your collective agreement says for surgery? If your collective agreement simply says you are entitled to leave if you're required to be quarantined, then you probably would be entitled to it in the same way that a collective agreement that says you're entitled to medical leave if you have to be hospitalized doesn't restrict you if you voluntarily decided to undergo a cosmetic procedure. If the collective agreement language is simply if you get medical leave if you're under quarantine, then it is, I think you'd be entitled to it. Again, it's one of these things people probably didn't turn their minds to when negotiating the collective agreement. But, if you negotiate a collective agreement provision saying you get medical leave if you're hospitalized, it doesn't really matter. So I would, from a public, just think about, and the way I'd approach it is this. If the employee doesn't get the quarantine leave because they've been out of on vacation, contrary to public health direction, what's likely going to happen? Well, the employee is probably not going to want to be at home, and denying people that quarantine leave may encourage people to show up to work when they shouldn't, or not tell the employer. So I think there's a good policy reason to say that if somebody has gone out, they're not disentitled to the collective agreement benefit, because ultimately keeping people that have been away from the country and exposed helps everybody. And if the employer doesn't like how their language is being interpreted and applied, then they can address it in bargaining.
Yeah, thanks for that. And then the final one. So if somebody was were sent home under public health officer direction because of a possible exposure, but turned out to be a false positive, is there recourse? And I'm assuming sent home without pay is the implication there.
Recourse against the employer, or a question against public health? Certainly, I don't think you've got any recourse against public health. I think if the employer, is acting in faith, I don't think the employer is going to be liable. One of the unfortunate things about COVID is we're acting in a new sphere, and our system does not impose strict liability. Our legal system, does accept that people make mistakes. So if the test result was just off, but people thought the person was, positive, it turned out not to be, I don't think there'd be any recourse, unfortunately.
Okay, so thanks a lot for your time and effort, to all the great panel members, Claudia, Christine, and Craig. I just
Okay.
noticed, oh, your name starts with C. So to the people watching it, I will flip an email the next day or two with a link to the YouTube channel where the recording will be posted, so you can come back and look at it. And I might be able to talk Craig and send me the PowerPoint, and I can put the link in there as well. Also
Only if they
notice.
promote CLC.
Okay, yeah, you have to subscribe to the YouTube channel. I also noticed that Christina did post that case she was talking about in the chat there, so I'll give people a few seconds to copy that. I'm getting quite a few people thanking you here. Thank you for the shout out to the BCGU as well. So that's great. So thank you very much for everybody who attended, and thanks again to the panelists. I thought it was a very interesting discussion and our most attended webinar yet of the school.
Woohoo.
So yeah.
Hey.
All
Thanks
right.
again.
Stay
Yeah.
safe, everybody.
Yeah, stay safe. Have a good evening, everybody. Thanks
Have
again.
a
Take
good
care.
night.
Bye.